Good morning and welcome to Melanie's Minutes, where we discuss workers' compensation issues by the beach. Today we are going to discuss the issue of 21 presumptions, so Section 21 of the Workers' Compensation Law, which afford the claimant presumptions that an injury occurred. And in order to successfully deny that claim and get the claim disallowed, the carrier has to overcome those presumptions. However, those presumptions are not a substitute for the claimant's burden to actually prove that an accident and an injury occur. A lot of times they seem to be a little too heavily relied upon in their prosecution of a workers' compensation claim. The claimant still has the burden. If, for example, if there is no contemporaneous medical evidence that support the claimant's treatment on the date of the injury, or that actually support that an injury occurred on that day, then the carrier should be arguing that there is no contemporaneous medical. Also, in the case of, let's say, an assault or something the claimant is claiming occurred, then it is the claimant's responsibility to produce a police report, assuming that there is one. We did have a recent file where the claim was disallowed, where on appeal, the claimant argued that this information was never directed to be produced. However, it's the claimant's burden. So just because there is the 21 presumptions that do work in favor of the claimant, that does not relieve them of the burden of proving that their injury occurred and making their case. A lot of times they do rely too heavily on that. And as carriers who are going to be defending the file, it's important to point that information out and to never allow a claimant to rely too heavily, or a judge. And we should be arguing that the claimant has to still meet that burden. So if you have any questions, about any newly deniable claims that you would like to discuss, we would be more than happy to discuss that with you. See you next time.